Accordingly, this court directs the respondent authorities to consider the claims of the petitioners by applying the same yardstick as has been done in other similarly situated units, and instances of which are placed before the court by referring to orders passed in the case of one Varun Beverages. If on facts and circumstances as applicable to the petitioners, their cases are found to be similarly situated as the other units or industries who have been given the benefit of extension for the period of exemption of taxes, then similar benefits must be granted to the petitioners. The respondent authorities will consider the claims of the petitioners in the light of the directions granted above within a period of 60 days from the date of receipt of a certified copy of this order. Respondent authorities will thereafter pass speaking order, and copies thereof will be served on the writ petitioners. Writ petitions are therefore allowed partly to the extent indicated and disposed of in terms of the above costs easy.
Please, Your Lordship, I recommended for listing on 9th
What is
of-
the subject matter and for
the petitioner was terminated from his service.
at what stage? Admission?
Yes, admission.
It should come up
9th of
huh?
9th of
9th.
9th of May.
All right, 9th of May.
Maybe the concept of other side, I recommend item number 42, hearing matter.
Yes.
Matter major for the day,
Why?
because my senior Mr. Waidula is in Bangalore, He's asked it's
42.
42, hearing.
42 items stands adjourned for a week. At the request made on behalf of Mr. Waidule, counsel for the petition. Respondent,
Yes,
have you informed the other side?
Yes, my lord.
Petitioners?
Yes, my lord.
All right. It is submitted that consent of the counsel for the petitioners have been obtained. Yes.
High level.
Lordship, my one is writ petition and it is for listing,
For what
for
purpose?
admission,
What subject?
dismissal from service.
All right. Let it come on 9th May.
Pardon?
9th May.
9th May, kindly, your Lordship, give 5, 6, 7 or 8.
Then it has to go after 9th.
We are having case in another court,
All right, 16th May.
16, highly applicable.
Made, please, Your Lordship. With due consent from the other side, I'd like to mention item number 37. Here in this matter, I am being led by Mr. Rohan Shah. He was supposed to come down yesterday and do the matter today, but yesterday a matter got spilled over in Supreme Court, so he could not come down to Guwahati today. So may I pray that the matter be taken up on 3rd of June, Your Lordship?
We don't know. Yes. We are just passing it over. Because this is a part of matter. We
understand.
can't
I
adjourn the
understand.
matter like that.
I totally understand, Your Lordship.
We can't adjourn it.
Your Lordship,
Yes, Mr. KL?
this is the outstation council, that's why, Your Lordship. I'm praying for date.
Outstation or otherwise, it is because of the prayer made on his behalf we fixed it today,
I understand, Your Lordship.
keeping his difficulties.
I understand, Your
Right.
Lordship.
So you have to also give due credence to the
Yes.
orders of the court.
Yes, Your Lordship. I bow down, Your Lordship.
22nd May.
Yes.
22nd is one date we can accommodate you if you are 22nd May. At the request of counsel for the
Interim order may continue.
item 37. 22nd of May. Mr. KL, any difficulty?
On 22nd, 9th here.
22nd May.
Interim order may
The
continue.
interim order passed earlier will continue till the next date. This is for hearing.
Hearing.
Yes,
Rule has been issued.
Rule has not been issued.
So it's for admission hearing.
No, hearing. It's for hearing.
Since
This pleadings were complete, Your Lordship.
hearing is complete, but it is not formally admitted.
It's not admitted. I think you have raised the dispute about
Maintainability of the writ petition.
maintainability, alternative remedy. So it's for admission.
Your Lordship may fix it for admission.
Matter be listed for admission hearing on 22nd.
Interim order may continue. Highly obliged.
Lordship, with the consent from the other side, I beg to mention item 30 to 32 of the daily list.
30?
30 to 32 of the daily list. Lordship, here GMC will be filing an affidavit. Lordship may kindly fix the matter after 1 week.
They do the they agreed by both parties, my lord. Well, the date was fixed as agreed by the both parties. No, from the next week, ठीक है, date may be fixed, madam. 6th or 9th, my lord.
6 or 9 could be difficult. We can have it on 6. Yes.
Lordship, my senior will be unavailable on that day, Mr. P. Nayak.
See, we are accommodating you.
Lordship.
You get your dates and inform the court which date is available. Why are you
Lordship,
not
8th,
informing us?
Lordship, 8th of May.
8th is good for you, Mr. Sharma?
Yes, madam.
All right, 8th of May.
Not too late.
Item number 30, 31, 32.
Yeah.
8th of May. 37 is on 22nd May. Huh? Yes.
May it please your lordship. Lordship, I beg to mention item number 41, lordship. Lordship, here the petition number 4, 19 and 20, they have one of them has expired and we have to substitute one of the petitioner, lordship. So we take some time.
41 to file you now.
This is fixed for hearing, lordship.
You have to file substitution.
Yes, lordship. Lordship, petitioner number 4 has expired, lordship.
Counsel to
And
the
petitioner number
petitioner submits that an application for substitution of legal heirs in respect of petitioner number 4.
Number 10, sir. Lordship, number 10.
Petitioner number 10
Yes, lord.
is
Suresh
required to be filed
Singh Rawat.
as he expired during the course of the pendency of the writ petition. He prays for 2 weeks' time, matter be listed for orders on the next date fixed by the registry.
Much obliged.
May I please, your lordship? My lord, I am praying for upgradation of one matter, lordship, item number 45.
Why?
My lord, this is the one urgent matter because, lordship, the petitioner has been removed from service, lordship, without initiating departmental proceeding. On the last day, when
No upgradation. It will
Okay.
be called up serially.
on the,
No upgradation.
on the last
What
of
is
the,
the urgency?
my lord, I am not in service, lordship.
You are not in service there. We'll hear you.
My lord, on
Wait
the
for
last,
your turn.
on the last of the when your lordship has posted this matter for hearing, suggested me to make mention to
We'll take it up.
lordship. Obliged.
May I please, your lordship, I beg to mention for listing one writ petition, lordship, for 2nd of April.
Why?
Lordship, pension matter last posted on 24/9.
For motion, admission,
Admission,
order,
lordship.
admission. List on 9th May.
Much obliged.
May it please your lordship. I beg to mention item number 13, your lordship. Praying for adjournment of the matter as because the learned counsel's father has passed away on 27th of this month, your lordship. We have taken the consent from the other side, your lordship.
You wait. This is a part of the series. This is a part of the series.
Yes, your
You
lordship.
have to wait for the matter to be called up. We can't accommodate you like this. This matter will go out of the series. Yes,
Madam, this matter may be listed for admission.
admission.
ID, my lord.
What is the subject matter?
Removal from service and it is pending, my lord. Yes, ma'am.
All right, 9.
Lordship, if I may. Lordship, I beg to mention item number 44 of the daily list. Lordship. Lordship, my senior is unable to attend today. It's his father's shraddh. So, Lordship, may kindly fix any other date, Lordship.
You mentioned when the matter is called up.
Lordship.
We'll see. Because this is a fixed matter.
Please, your lordship, lordship, affidavit is for vetting, lordship, may kindly accommodate 2 days' time only. Lordship.
MM Kotoki, learned standing counsel, veterinary,
Animal husbandry and veterinary department.
animal husbandry and veterinary subjects that she would like to file the affidavit. The affidavit on behalf of the department is under process and you'd like to be, and could be filed within the course of this week?
Lordship.
Accordingly, the writ petition stands deferred to be listed after 2 weeks.
Date may be fixed, Lord.
You see the affidavit. If you want to file reply, you file. Otherwise, you make a mention.
But-
After 2 weeks.
Obliged.
May I please, Lordship? In this matter, we have filed our affidavit in some matters, Lordship, and some will be filed during the course of the day, Lordship.
Which matters you have filed?
We have, I have filed 4, 5, 11, 13,
Give us 4, 5, 4 and 5.
28.
But some of the cases, 4, 5, I received the affidavit yesterday evening around 3:30. I have not been able to go through it.
Okay.
What I was praying is, my lord, if this matters, we'll just need to go through it because what I have been told is they are similar. If they can be taken up on Tuesday. Since it is whatever is convenient to the court, my lord, it's not the earliest, my lord, if it is not taken up on Tuesday. We agree that we'll go through the affidavits, we'll make our submissions. Just that much of time.
So you are making a submission on behalf of your clients.
3,
There
4,
may be
5.
others who may like to file a reply.
Yes. Some cases affidavit not even filed.
In my cases, I have not received the affidavit.
Lordship,
Item number
today
9.
is- Today is
We'll
going
give it
first.
for 8th.
Done.
8th.
Lordship, let it be on 13th, Lordship.
Why? You are filing during the course of the day.
During the course of the day,
then-
8, 9, I'm not there, Lordship. I'm not there, Lordship. That's why.
All right, 13th.
13th.
The request made by the council for the respondent that they are in the process of filing counter affidavits in these bunch of petitions. Matter stands deferred. As agreed to, as prayed for. Matter be listed on 13th of May. 13th of May.
13th of May. Yes.
Much obliged.
Interim orders, can you continue?
Interim orders wherever passed will continue till the next date fixed.
I'm deeply obliged.
Much obliged.
Yes.
Here also, Lordship, affidavit is not yet filed, Lordship, but the implemented respondent, Lordship, newly implemented respondent, Lordship.
Hmm?
Newly implemented respondent, Lordship.
Newly implemented.
Yes, Lordship.
You have taken steps.
Yes, Lordship.
Who are the newly implemented?
Lordship, PC, Principal Controller of Defense Accounts, Lordship.
It is submitted by the council for the petitioner that yes.
Lordship, I am for respondent number 4 and 5. My senior is on legs on another court.
So who's for the any CGC here?
Take it.
None appears for the respondent number 6 when the matter is called up. MS Wenso submits that you are appearing on behalf of
Respondent number 4 and 5.
4 and 5. Appears on behalf of respondent 4 and 5. No counter affidavit has been filed. Matter be listed for admission hearing on the next available date on a date to be fixed by the registry. Yes. Next available date fixed by the registry.
May please the Lordship. Here, Lordship, I am seeking the benefit of Upen Das, Lordship. They have filed affidavit and I have filed my reply also. Forest Department pending consultation.
Forest Department.
Yes, Lordship. Maybe,
Their names are shown.
yes, Lordship. Maybe taken at after some time. My case was forwarded, Lordship. First time when it was forwarded, the list of all casual workers, Lordship, the name of the petitioner left out. And thereafter, again, 9 workers' names were, Lordship, forwarded. In that list, my name was there, Lordship.
What is the stand of the respondents?
They are saying that, Lordship, since 2014, I am not working, Lordship. There is no record. But, Lordship, from 1993, I am working till 2014. Even if, Lordship, assuming for argument's sake, we admit the stand of the respondent, Lordship. Then also, I have already worked 10 years, Lordship. But
If you work 10 years, whatever area is there, you'll get it. But
nothing was paid, Lordship, no consideration. But Upenda says, Lordship,
if you are not in service, where's the question of giving you the
Lordship,
consideration?
that I'm only for argument's sake, I'm saying, Lordship. Otherwise, Lordship, my case was forwarded in the year 2021. How they can say that I am not in work since 2014, Lordship? I have enclosed all the annexures, Lordship. Page annexure 6, page 42, your Lordship will find. From CCF to PCCF, Lordship, my recommendation was done on 31/2020. So how can they take a standard since 2014? I am not working, Lordship. Page 42, annexure 6. Page 42, second paragraph, Lordship. In this connection, as verified by Divisional Forest Officer, Karimganj Division, I would like to inform you that Sri Ali Haidar Borbhuia has been working as casual worker on daily basis under Karimganj Forest Division since 1993. The name of the petitioner was forwarded along with left out casual workers working prior to 1/4/1993 under Karimganj Division bearing so-and-so to the CCF LHZ under cover of this office letter number so-and-so. Accordingly, the list of the said left of casual workers under Karimganj Division was submitted to the PCCF and HOFF Assam by the so-and-so letter, Lordship. Later on, the additional PCCF submitted a list of 187 numbers of left out casual workers under Karimganj Division along with the list of left out casual workers of other divisions under Conservator of Forest, Central Assam Circle and Conservator of Forest, Southern Assam Circle for furnishing the bank account of the left out casual workers as per list enclosed therewith. But the name of the petitioner did not appear in the list of 187 numbers of left out casual workers under Karimganj Division received from additional PCCF. However, the DFO Karimganj Division had submitted the bank account of 187 numbers of left out casual workers as per list forwarded by the additional PCCF along with another statement showing the particulars of 7 numbers of casual workers, including the name of petitioner along with their supporting documents, whose names were forwarded earlier but not appeared in the list of 187 numbers of left out casual workers received from additional PCCF. Accordingly, the bank account number so-and-so of left of casual workers under Karimganj Division along with the particulars of another 7 numbers of casual workers whose names were forwarded earlier along with the list of above 187 numbers of casual workers left out, but their names were not appeared in the list received from additional PCCF had been forwarded to the additional PCCF under cover of this letter, office letter number so-and-so, in the year 2014, Lordship, for favor of onward action. Thereafter, the additional PCCF under cover of this letter number so-and-so had forwarded the list of left out casual workers under Karimganj Division to PCCF and HOFF Assam, but no communication in respect of inclusion of the name of Sri Ali Haidar Borbhuia as left out casual worker has yet been received from your end. In view of the above facts and circumstances, I would request you to kindly look into the matter and take necessary step to include the name of Sri Ali Haidar Borbhaiya in the list of left out casual workers under Karimganj division if deemed fit and proper, as the petitioner has been working as casual worker under Karimganj division prior to 1/4/1993. Thereafter, Lordship, I have prepared one writ petition, that is Annexure 7, page 44, Lordship.
No, in the speaking order,
Lordship.
there is a, it is mentioned that your name did not figure in the list received from the divisional forest office.
But Lordship, it was in the first list, my name was not forwarded, Lordship, it was left out. Similarly situated other persons are there, Lordship, so accordingly 7 or 9 persons name again forwarded, Lordship. I have just read out the communication, Lordship, which reflects that.
In this 187, your name was there.
Second time also it did not appear. So Lordship, for that 2020 communication was made, Lordship. My DFO was asked to forward the account number of the petitioner, Lordship. Accordingly, all the details of account of the petitioner was forwarded, Lordship. And Lordship, when I prepared the writ petition, the stand taken by the respondent in page 45, Lordship, paragraph 2, Mr. I. Borthakur Lanet, Standing Counsel, Forest Department, submits that if the petitioner file a fresh representation, their cases will be considered by the department and appropriate orders thereon will be passed. On that basis, Lordship, that writ petition was disposed of.
What happened to the, any reply received in respect of this letter? Page number 42 of the writ petition.
But after this letter, this repetition, this page 44, that was filed. No, since no reply was received, this since there's no whisper of any reply being received by department, but after this letter, this writ petition 134/2023 was filed. Thereafter, the order was passed. Let him file a fresh representation. The authority will pass speaking order, and thereafter speaking order was passed.
No, no, no.
But
You
letter
come
is
to page
dated
number 42. This is a letter issued by Chief Conservator of Forest.
Chief Conservator of Forest.
To the PCCF.
To the PCF.
You come to the second paragraph. Somewhere in the middle, you will find, however, the DFO Karimganj division.
Yes.
Submitted.
Bank account number.
So and so. Left out workers. Along with another statement, including the names of the petitioner. But in the speaking order, you say that in the list submitted, his name did not figure. So how many lists were submitted? Yes. The order at page 50,
Yes,
serial number 7 gives a very categorical
yes.
binding names not received.
This just says that name of Sri Ali Haidar, son of son, did not figure in the list, which is division for Karimganj, and hence the name did not figure in the list, subnet PCF, Assam, so and so, dated 7 June 2019. But on letter at page 42, Your Lordship, it says that accordingly, the list of said casual worker in Karimganj was submitted Assam by so and so, so and so. It is of 2011. 2011, the 1, 2, 3, 4, 5, 6, 7, the seventh line, Your Lordship. The addition. Later on, the addition PCF LAG submitted a list of 187 numbers of left out casual workers under Karimganj division, along with the list of left out casual workers of other division under considered for Central Assam and considered for Southern Circle of Assam for furnishing the bank account of the left out casual workers as per list enclosed therewith. But the name of the petition did not appear in the list of 187 numbers of casual left out workers under Karimganj division received under the additional PCF so and so. However, DFO Karimganj division submitted bank account number 187 casual workers as per list forwarded by the additional PCF along with other statements showing the particular 7 number casual workers with the name of the petitioner along with the supporting documents whose names were forwarded earlier but not
DFO had submitted the list.
he has submitted the list. In 2011, there was one list. His name was not there. Again, a list of sent. In 2019, the beginner says his name was not there.
Right. So therefore, this para 7 has to be elaborated in your order at page 50.
Exactly, Your Lordship.
Why do they say the names were not
They say that in 2019 there was no name, but in 2011, in there are two lists, most probably there's no name, but in middle one there's supposed to be a name.
Quite right. So what is to be done now?
Lordship, let me get the instruction whether this 3 lists, in which of the lists a petition name was included. Because from this record, it seems there are 3 lists.
We are now examining the correctness of this order.
Yes, Your Lordship.
This order at para 7 merely says names were not received.
Yes. There's a
Which
name
list?
Name not received, but in
which list? In the list submitted by so and so, dated so and so.
But at para 11 of the order, Your Lordship, may you kindly see Division Forest of the Karimganj. So when submitted the Shri Ali Haidar sir did not attend any work under Kailan Range, Karimganj division since 10 February 2014.
This is in 23. Since 2014.
Since 2014.
Right. But the earlier list was submitted on?
First list was most likely in 2011.
Yes. Then
I have enclosed the list submitted, my name, when my name was submitted, Lordship.
where is that?
Yes, Lordship, page 21. They are saying since February I am not in work, but the list was submitted on 8/9/14.
When was this submitted?
It was
Lordship, the last signature, your Lordship will find 8/9/14 at the bottom of the letter, Lordship.
Hardly eligible.
First one is eligible, Lordship, 8/9.
Page 21 on the top right side, so the date is given 8/9/2014.
8/9/2014.
Yes. And the list includes my name in serial number 3, Lordship, page 22.
But the statement at 51 says 10 February 2014 you have not worked.
Yes.
So there is some dispute with regard to facts. By your own documents, this page number 21 is a document of the DFO.
DFO. It says that list was given 2014. The name of the petitioner was there. But the speaking order says that he is not working since February 2014.
Then do you reconsider this order? Pass a fresh order.
Very well. That is taking account of this letter to the 8/9/2014. Taking account the list which was submitted by DFO.
Yes.
8/9/2014. That will.
Yes. But and it comes from 40 parties. The petitioner is before this court for the second time. The petitioner was engaged as a casual worker. At the Kaline, under the Kaline Forest Range, under Karimganj Forest Division, since March 1993. During the process undertaken by the respondent authorities for granting of minimum scale of pay in terms of the order dated 8/6/2017, passed in writ appeal number 45 of 2014. The names of several casual workers, including the petitioner, was required to be submitted. Stop. However, the name of the petitioner was inadvertently left out. So, subsequently, the department, the concerned DFO, furnished a list of 7 casual workers, including the writ petitioner, for due consideration of the benefits to be granted in terms of the judgment and order dated so and so, passed in writ appeal 45 within bracket Upenda Supra. So,
8/6/17.
however, the name of the petitioner, however, no consequential orders were passed. The petitioner represented before the authority, and that representation, however, was also not. Did you file any representation?
After writ petition, I have filed.
With first writ petition.
First writ petition.
Before that, it did not.
Before that, Lordship, there was communicated.
The petitioner, line to continue, there was no information given to the petitioner with regard to his claim for grant of minimum scale of pay. Being thus situated, the petitioner approached this court by filing WPC 1342 of 2020. On the day the matter was called up, taking into consideration the submissions made by the counsel for the forest department, that if the petitioner files a fresh representation, his case will be considered and appropriate orders will be passed. The writ petition was disposed of, permitting the petitioner to approach the authority and file a fresh representation for inclusion of his name and for grant of minimum scale of pay, as have been done in cases of other similarly situated persons. Stop. It was further directed that once a representation is filed, the same shall be considered and disposed of by passing a speaking order within 30 days from the date of receipt of a certified copy of the sum. So, pursuant to the orders passed by this court, the petitioner filed his representation dated 1/2/2024. The authorities, upon due consideration of the representation filed, disposed of the petition of the petitioner by a speaking order dated 2nd of April 2024. By the said order, the claim of the petitioner was rejected on the ground that the name of the petitioner did not figure. No, you're right. One of the grounds, as reflected in para 7 of the impugned order, reflects that the name of the petitioner did not figure in the list received from the divisional forest officer, Karimganj Division, Karimganj. And therefore, his name did not figure in the list submitted by the PCCF and HOFF Assam. ID reference number so and so dated 7 June 2019, page number 50. So, it was further mentioned at para 11 of the said order, impugned order, that as per communication dated 22nd of June 2023, submitted by the Divisional Forest Officer, Karimganj Division, Karimganj. The petitioner did not attend any work under Kaline Range, Karimganj Division since 10th of February 2014. Stop. Under such circumstances, the claim of the petitioner was rejected. Stop being agreed, the present petition has been filed. Pursuant to the notice, the respondents have filed an affidavit. Respondent number 3 has filed an affidavit. Whereby it is stated that as per the communications received from the DFO Kaline Range, the petitioner did not attend any work since 10/2/2014. And accordingly, his case could not be considered for grant of minimum scale of pay. Council representing the Forest Department also reiterates that the petitioner, that in the communication forwarded by the DFO Kaline Range, Kaline Forest Range, and the Karimganj Forest Division, the petitioner was not found to be in service since 10/2/2014, and accordingly, his case was not considered. So, counsel for the petitioner, however, submits that the petitioner's name was duly forwarded by the DFO Karimganj Division along with 7 other persons. Stop. Under such circumstances, the contention of the respondents that the petitioner was not in service with effect from 10/2/2014 is incorrect and not tenable. Counsel for the parties have been heard. The pleadings available on record have been perused. It is seen that by communication dated 8/9/2014, issued by the Divisional Forest Officer, Karimganj Division, Karimganj, issued to the Conservator of Forest, Southern Assam Circle, Silchar, Hyderabad, Qatar. Names of certain casual workers, some casual workers, names of 7 casual workers, along with their supporting documents, which were forwarded earlier by the office of the DFO, Karimganj, but which did not appear in the list of 187 numbers of casual workers received from the Principal Chief Conservator of Forest and Head of Forest Force, ID, communication number so and so dated 21/6/2014, page number 21, comma. The name of the petitioner was found at serial number 3 in the said in the statement enclosed to the communication dated 8/9/2014 issued by the DFO Karimganj Division, Karimganj. Stop. The petitioner was shown to be in engagement of the department since March 1993. The statement was also endorsed by the DFO Karimganj Forest Division, Karimganj, dated 8/9/2014. Stop. Further, in the communication issued by the Chief Conservator of Forests, Southern Assam Circle, Silchar, dated 30/31/2020 to the PCCF and HOFF, it was clearly mentioned that the DFO Karimganj had submitted the bank accounts of 187 numbers of left out casual workers as per the list forwarded by additional PCCF within bracket T, LAZ, along with another statement showing the particulars of 7 numbers of casual workers, including the names of the petitioner, along with their supporting document, which names were earlier forwarded but did not appear in the list of 187 numbers of left out casual workers received from additional PCCF within bracket T, bracket close, comma, LAZ. ID communication dated 8/9/2014. Stop. In the said communication, it was clearly mentioned that pursuant to the communication issued by the DFO enclosing the name of the 7 casual workers, including that of the writ petitioner, no further communication was received. It is further mentioned in the said communication that pursuant to the list submitted, list of left out casual workers under Karimganj division was submitted to the PCCF and HOFF, which by the DFO Karimganj Forest Division, which included the name of the present petitioner, no communication was received for inclusion in respect of the inclusion of the name of the petitioner as left out casual worker. So, that under such circumstances, it is evident that the DFO Karimganj Forest Division had submitted a list of casual workers which were found to be left out from the original list submitted, and which list and the said subsequent list of 7 casual workers also contain the name of the present petitioner along with all particulars. Stop. The further communication from the Office of the Chief Conservator of Forest clearly makes a reference to the said communication issued by the DFO. Stop. Under such circumstances, the finding of the PCCF, who passed this order?
So order was Principal Chief Conservator of Forest.
PCCF, that the name of the petitioner was not found in the list forwarded by the concerned DFO does not appear to be correct on facts. The further statement that the petitioner was further statement at serial number 11 of the said order that the petitioner was not found to be in service or attend work under Kaline Range, Karimganj Division since 10th of February 2014 is also not found to be correct on facts. Stop. In the affidavit filed by respondent number 3, there is no denial of the communication. There is no denial that the communications dated 8/9/2014 and the subsequent communication issued by the DFO, Karimganj Forest Division, and the communication dated 31/2020 issued by the Chief Conservator of Forests, Southern Assam Circle, Silchar, was issued. Stop. Under such circumstances, it is clear that the order, impugned order dated so and so, passed by the PCCF, was passed without taking into consideration the aforementioned communications. Stop. In fact, the impugned order has no reference to the aforementioned communications. Stop. This, in the view of the court, would require the department to revisit and pass a fresh order in respect of the claims made by the petitioner on the representation filed pursuant to the order dated so and so, passed WPC so and so. Order dated
24/1/24, Lordship.
24/1/24,
24,
passed in WPC number
Lordship, 1342, 2023,
1342 of
page
2020.
44.
So the impugned order dated so and so is therefore set aside. The matter is remanded back to the PCCF to pass the order afresh, to pass the speaking order afresh. While passing the speaking order, the PCCF will examine the entire records and thereupon pass appropriate orders. Stop. The speaking order should also reflect the document, the speaking order will also reflect as to speaking order should also reflect the position as available from the departmental records as to why the name of the petitioner along with the other 7 left out casual workers, which were submitted by communication dated 8/9/2014 by the DFO, was not considered. End of rigor, if considered, what consequential orders thereon were passed, denying the benefit of minimum scale of pay to the petitioner and other similarly situated persons mentioned in the list. The impugned order, therefore, in view of the directions issued by the court today, the matter is remanded back. The authorities will revisit the issue and pass appropriate orders within 30 days from the date of receipt of a
Particularly
certified
respondent
copy of
number
this order.
3, Lordship.
Hmm.
More particularly respondent number 3.
PCCF. You have said PCCF.
Lordship. And Lordship asked me whether any representation was filed by the petitioner on 26/11/19.
Not necessary.
That is already annexed, page 41.
Not necessary.
Obliged, Lord.
Obliged, Lordship.
These 2 writ petitions filed, my lord. One is for non-payment of gratuity and another is with regard to wrong calculation of leave encashment benefits
Yes.
awarded to the petitioner. The
Yes.
35, item 35, this is writ petition number 3534 of 2024. It's a case for, my lord, non-payment of gratuity. They have filed an affidavit in opposition with the objection that I am not entitled to the gratuity as because I have resigned from the service of the department and joined another department. But so far as section 4 of the Payment of Gratuity Act is concerned, even the
gratuity. Payment of gratuity. Yes, carry on.
Payment of Gratuity Act is concerned, it includes an employee who has resigned from the service. So I have resigned through the proper channel after obtaining the NOC from the department.
Section 4.
Section 4, my lord.
Yeah.
The gratuity shall be payable to an employee on the termination of his employment after he has rendered continuous service for not less than 5 years, perhaps more than 5 years, on his superannuation, on his retirement or resignation. So I have resigned from the service and joined another central government undertaking. So the objection raised by the department is not sustainable in view of the provision contained in Payment of Gratuity Act.
Yeah. What is their objection?
They have come up with an objection that since I have resigned from the service, so I am not entitled to the Payment of Gratuity Act. Paragraph 12.
Yes.
That with regard to the statements made in paragraph 14 to the writ petition, the deponent respectfully states that the office order dated 17/8/2021 issued by APGCL extending the benefit of death cum retirement gratuity to its employees covered under MPS shall be on the same terms and conditions which are applicable to the employees covered under CCS Rule 1972. Opposite to state here the Rule 50 of CCS Rules 1972 corresponds to admissibility of retirement gratuity to a government servant on his retirement from service on attaining the age of superannuation after completion of qualifying service of 5 years. It can further be substantiated with the help of office memorandum of so-and-so, dated 11th October 2022, and in view of the above provisions, the petitioner is not entitled for retirement gratuity from APGCL as he has resigned and not retired from APGCL. So it is contrary to the provision contained in the Payment of Gratuity Act, this is Section 4.
Yes. There's a difference between this office, the office memorandum and they say that you are entitled as per the office memorandum.
Yes.
So how are you affected by that?
I am affected by, as per the Payment of Gratuity Act, well, this Gratuity Act is defined in the Act of 1972.
Right.
So who are the employees entitled to the payment of gratuity? So here the as per Section 4B, it is the employee who has resigned also entitled to get the benefit.
But they say that you are entitled as per the office memorandum.
The office memorandum, my lord, in my humble submission cannot supersede the definition of the Central Act.
That's what I'm asking you. How are you affected by the office memorandum? You are getting less amount of money.
But I am not getting anything. They have not given anything to me.
So, but it says retirement gratuity and death gratuity.
Yes. It is as per the office memorandum, retirement gratuity and that, my lord. And so far as the gratuity is defined, my lord, the employees,
You had resigned.
I have resigned. And I have joined the central government undertaking department.
So, Mr. Nath, you are saying that this office memorandum is applicable only for retirement and death,
Lordship,
not for resignation.
no. Lord, two conditions are there, my lord. We have adopted well, this is the company, my lord. The board of directors is the highest authority in the company. They have adopted some provisions of the CCS pension rules and some of the office memorandum. So the order in the writ petition they have annexed at page number 41, 17/8/2021. That is the office order.
Yes.
Page number 41, the office order is 17/8/2021. This provides, my lord, that the APGCL board by resolution number 19 in its 91st
Sorry,
meeting dated
page number?
Page number 41, Annexure D in the writ petition.
Page number 41. Okay.
This is the decision of the company. The APGCL board by resolution number 19 in its 91st meeting dated 29/7/2021 approved for extending the benefit of death cum retirement gratuity to the employees of the Assam Power Generation Company Limited covered under NPS on the same terms and conditions as are applicable to the employees covered under CCS Pension Rules 1972 prevailing in APGCL. The board considered and approved for grant of DCRC benefit to the employees of APGCL who have joined APGCL and comes under the NPS, keeping in view the benefit of DCRC provided by the office memorandum number so and so dated 1/1/2021 of the to the NPS employees of the government of Assam. So in tune of that office memorandum of 1/2/2021, this decision has been taken by the board. The benefit will be applicable to those employees who have joined APGCL service on or after 1/1/2004. Now, my lord, as per this, kindly in our come to the affidavit in opposition file by us, my lord. The 1, 2, and 3 has filed the affidavit. Paragraph number 9 we have stated, my lord.
Yes.
That with regard to the statements made in paragraph 7 of the writ petition, the deponent respectfully states that the APGCL by office order number so and so dated 17/8/2021, which I have read, my lord, has extended the benefit of death cum retirement gratuity to the employees of the APGCL covered under the NPS on the same terms and conditions as are applicable to the employees covered under the CCS Pension Rules 1972 prevailing in APGCL and keeping viewed the benefit of DCRG provided by the office memorandum dated 1/2/2021 to the NPS employees of the government of Assam. So this 1/2/2021 office memorandum we have annexed to the affidavit. It is at page number 64, annexure 1. This provides the extension of benefit of retirement gratuity and death gratuity to the state employees, state government employees covered by new defined contribution pension scheme NPS regarding. The government servant appointed on or after 1/2/2005 are regulated by the new defined contribution pension scheme known as NPS, notified by the Finance Budget Department circular number so and so dated 25/1/2005. Later on, orders were issued for payment of gratuity on provisional basis in respect of employees covered under NPS on their retirement from government service, on invalidation or death in service. So these are the two criteria, not conditions. The issue of grant of gratuity in respect of government employees covered by the NPS has been under consideration of the government for some time. After careful examination, it has been decided that the government employees covered by NPS shall be eligible for benefit of retirement gratuity and death gratuity on the same terms and conditions as are applicable to the employees covered by Assam Services Pension Rules 1969. So, as per the spirit of this office memorandum, that decision has been taken by the board. So,
now the question is that this consists of only two circumstance, death and retirement.
Lordship.
But what happens to resignation?
Well, that we have not recognized.
But where is that resolution to say that you have not recognized?
But we have said that under these two circumstances, the office memorandum of 1st of February 2021, it clarifies that these are the two conditions: retirement gratuity and death gratuity. In fact, retirement in case of invalidation is also included. But my lord, the resignation, because the person concerned has resigned here after 7 years of service, he responded to a direct recruitment initiated by other organization, and accordingly he got selected and he resigned. So that has not been considered here. Ultimately, kindly see, the gratuity is, my lord, the concept of gratuity. It's a after, my lord, providing service to the organization. It's a as a gratuity, my lord, as a gratitude, the amount is paid.
Gratuity comes under what provision?
Where
does the concept of gratuity come?
My lord, the concept is available. Gratuity, my lord, as per the Payment of Gratuity Act is there. It is there, my lord, but gratuity, payment of gratuity is regulated by the pension rules. Ultimately, the service benefit to be paid to an employee, that has to be as per the rules of the particular institution, my lord. Now here in the APGCL, the service condition applicable to the employee is the order dated 17/8/2021, my lord.
You show us on what basis you are saying that benefits under the Payment of Gratuity Act are to be regulated by the rules of the
But in fact, for payment
the
of
act is an act of the parliament.
this is
The
an
act
act.
is very categorical.
But
Firstly, you have to be an employee as defined under section E. Sorry, 2E. 3E. Is it 3E? Sorry, 2E. You have to be an employee.
Lordship.
Now, who is an employee is defined here. Whether his services under your company will render him to be an employee under the Payment of Gratuity Act would have been a question. But then you are already allowing your employees to draw gratuity for retirement and death.
That gratuity.
So therefore, there is by your own conduct, you have allowed these employees to be understood to be employees as defined under Gratuity Act.
But
Because you have accepted death and retirement.
conditions are there, conditional.
Now, when is the gratuity to be paid is defined in section 4, which includes resignation.
Well, in fact, my lord, the gratuity under the Payment of Gratuity Act is a statutory right, my lord. But the authority has the particular authority of the organization, my lord. They have the power to regulate the service conditions of the employee.
You can regulate, but you can't deny.
You
can regulate.
In fact, while doing that, the order of
Regulation will not include private. You can regulate.
Well, it's the service condition, my lord, employee concerns are governed by that, my lord. Ultimately, the office memorandum of the government of Assam.
Employees are governed by that, but what will be the position of an individual vis-a-vis the rights guaranteed under a law validly adopted by the government? It's a central law.
Well,
this is binding on all the government and departments and the individual. Unless there is an exception carved out that this particular law under certain such circumstances will not be applicable. This is applicable.
So for the claim of gratuity is concerned, my lord, this is being followed in the company. Well, of course, my lord, lordship has indicated. Lordship has indicated. Lordship has indicated because this doesn't say that apart from this, others we are explicitly it doesn't say. Explicitly doesn't say, but it is being followed, and what is in their mind, my lord, under what exceptions they have carved out.
No. You may follow. There is no. We are not putting headers on whatever you want to follow. But The question before the court today
Lord.
is whether he has a right under the statute. The statute on a plain reading says person will be entitled for gratuity on other, besides other, on resignation. Now he has admittedly resigned from your company. Now you are adopting a particular poem and to give an interpretation that is only in these circumstances gratuity paid, no other. That amounts to deprivation to the petition, whether it is a valid deprivation.
But exceptions are there, my lordship, because the office memorandum of the government of Assam also says only two
Does not
conditions.
provide for any exception.
Two conditions are there.
Conditions are there because it does not explicitly exclude the other instance. It says, it does not say that only death and retirement will give you credit. If there is any office memorandum, place it for us. It does not say that because by these office memoranda, the provisions of the act cannot be amended.
No, I got the point.
Provisions of the act cannot be amended.
If unless the authority is empowered to do that, if authority is given the option that they can frame rules despite the act, they
Either
can,
normally, either the provisions of gratuity act is applicable, or you are entitled to frame your own rule for gratuity.
lodge.
But you frame, then supposing you have given the employee some option, was any option given to you earlier?
No, madam.
No. Because
Whether
the-
you'll accept gratuity act for the rule. If they adopt your rule, if they accept your rule, then perhaps they may be precluded.
well, the employee concern when he is under the service of the company, he has to be governed by the what is existing in company.
Correct.
He has no option to do that.
There is no quarrel on that.
Lord.
But can the company, which is registered under the laws of the country, ignore a law made by the parliament?
Lord, my respectful submission is that they cannot ignore, but
So
the
ignorance,
since
ignoring
Lord,
means ignoring to the extent of depriving a right which an individual is claiming under a particular statute.
Lord, they must have the leeway to do this. Otherwise, they will not do. But at this moment, my lord, I may not be in a position to apprise the honorable court under what provision they have done, because the board has taken a decision. Possibly they have examined that aspect and they have done. But I'm my lord, submitting my lord, that at this moment, my lord, possibly I may not be in a position to apprise the lordship. The what circumstances they have done. Otherwise, the statutory authorities, they must have something.
You
Otherwise,
get
true.
it.
Your
Your affidavit does not elaborate on this aspect.
my lord, in fact, we have referred that in the spirit of the office memorandum of the government of Assam, which I have read at page 64. This also provides only death and retirement gratuity, and in the spirit of the pension rules 1969.
You read the entire office memorandum.
Yes, my lord. The issue of my lord,
Issue of gratuity.
the issue of grant of gratuity in respect of government employees covered by the National Pension Scheme has been under consideration of the government for some time. After careful examination, it has been decided that the government employees covered by the NPS shall be eligible for benefit of retirement gratuity and death gratuity on the same terms and conditions as are applicable to employees covered by Assam Services Pension Rules 1969. So in the tune of the spirit of the Pension Rules 1969, this office memorandum has come that in case of NPS employees also, the present petitioner is also an NPS employee.
What does the pension rule say about gratuity?
It is death come retirement gratuity.
Pension. Yes. Rule number?
201, my lord, 257, page number 20, rule 207, 1.
Yes.
It provides death cum retirement gratuity 201 when a government servant whose death cum retirement gratuity is payable in India is likely to retire before the amount of gratuity can be finally assessed and settled in accordance with the procedure mentioned earlier. The audit official to ensure this refers to rule
This
one.
is the procedure.
Logic. This refers to 135. Section 2 death cum retirement gratuity. An officer who has completed 5 years qualifying service may be granted additional gratuity not exceeding the amount specified in sub-rule 3 when he retires from service and is eligible for gratuity or pension under rule 101 or and 111. All these rules, it refers to retirement gratuity only. The 5 years is the qualifying service. It is not a case that you complete 5 years, get the gratuity and leave the service. After completion of the entire service tenure, and if the qualifying service, minimum qualifying service is
You
not
have
there,
to satisfy the court
Madam.
that an authority or a department will have the liberty to
That-
frame its own rules for grant or denial of,
Logic.
and the provision of the statute enables you to.
But I have to apprise the honorable court that because the authority has exercised their power, I would submit that they definitely have some source. I'll apprise
You
the-
examine and tell us.
Yes, yes, Madam. I'll do that. I'll do that.
Yes, Mr. Biswas.
My lord, these are the rules, my lord. This office memorandum frame not frame under Article 309 of the Constitution of India, my lord. And these are their internal communication. And so far as my writ petition is concerned, if I may take your lordship to page 50, the authorities has written, or the general manager written to the chief general manager for a clarification as to whether the resigned employee are entitled to get the gratuity under the act or not, my lord. There is no reply has come till today, my lord. And your lordship is aware the Mahendra Singh Gill case, my lord. What is not there in the, my lord, office memorandum or the my lord, replies cannot be brought before this honorable court by a fair affidavit in opposition. They have not taken any action till today. And Payment of Gratuity Act, my lord, it's a act, my lord, Central Government Act, my lord, Central Act. And these office memorandums are their internal communication, not framed under Article 3.
Are you relying on any authorities
Regarding
your claims under Gratuity Act?
from the act itself, my lord, it is clear.
No. The department has taken a stand that here the payment of gratuity will be governed by the OMs, which lists out two instances, which is death and retirement.
These OMs will not hold good, my lord, for the simple reason, my lord, these are not the, my lord, OMs, my lord, formulated under Article 309 of the Constitution of India. And that's why, my lord, it cannot supersede the, my lord, Central Act, the act enacted by the Parliament.
Yes, Mr. Nath, anything you want to submit on
Malad-
this suspect?
Malad, the service conditions, Malad, in service conditions, Malad, are there, and Malad, the petitioner's entitlement or a government employee's entitlement has to be as per the service rules, Malad, prevailing in the organization. Malad,
Where are your service rules?
Malad, as regard the gratuity, Malad,
Malad, there is no service rules.
that is the page 41. That governs the gratuity, payment of gratuity, Malad, in the writ petition, page number 41.
And in the representation, some communication is there. What reply have you given? Where is that communication? By your
Page
officer?
50, my lord.
It's an internal communication, my lord. My
Yes.
lordship may consider one thing, my lord. My lord, when something is under consideration in a department, the lower officer seeks a clarification from the higher officer. My lord, ultimately, the higher
We are asking you something very simple and very clear, for which we appreciate a clear answer if you have one. The question which we have posed before you is, can you deprive a citizen of the rights specified under a statute by way of an office memorandum?
In that response, my lord, I have submitted before the honorable court that I will examine. I'll come back to
You
that.
tell us how much time you require then.
Lordship may give me 10 days time, my lord. I'll come back, my lord.
Matter deferred 2 weeks on the request made by Mr. D. Nath, learned counsel representing the APDCL.
APGCL, my lord.
APGCL.
1, 2, 3.
To
1, 2, 3.
examine the claims of the petitioner under the Payment of Gratuity Act 1970. Vis-a-vis the OM stated.
The office order dated 17/8/2021.
17.
That is the ultimate decision. That is our ultimate decision.
Okay. The rights of the petitioner under the Payment of Gratuity Act 1970. List again after 2 weeks. Mr. S. Biswas appears for the writ petition. List according. May 20.
Master bullet.
You are supposed to file some affidavit.
Lordship, we've received the instructions. Lordship may kindly allow us 1 week time, we'll get it filed.
And appears for the petitioners on call. MS
A. Bodhakur.
A. Bodhakur, learned counsel representing Mr. P. Nayak, Regional AG, Assam. Prays for further week's time to file the affidavit as permitted by the court by its earlier order dated 26/03/2025. List again after 1 week.
Obliged.
Made bill of my lord. The case relates to my removal from service after 32 years of its
Removal from service.
Yes. Without following the rules, it's prescribed, my lord. Well, before I go into the facts of the case, my lord, let me first, my lord, where the department has defaulted in following the rules. Number one is no list of documents and witness was furnished along with the charge sheet, which is compulsory, invariably required. Number two is no statement of allegations there. Then number three is, my lord, no defense assistant was given in spite of my asking. No cross examination and no inquiry report furnished till date.
No inquiry report furnished.
No.
Lordship, in this matter, Lordship, Mr. Kekpor will appear, but Lordship, one election matter was going on in court number 9, Lordship. So, Lordship, kindly matter may adjourn for today, Lordship, if possible, Lordship.
You have to give us the information whether inquiry report was furnished or not. If so, on which day. Please get the information and come back.
The charge the very charge is defective. Charge will go to go. You'll also kindly come to page or the charge sheet. Page 20.
Yes.
Rule 9 निकालो, whatever. Page 20, my lord, even there, the amount of alleged defamation, there was a criminal case, my lord, he has been honorably acquitted in the criminal case on the same allegation. There was a criminal case against him, against the petitioner. He was honorably acquitted, my lord, by the court.
No, you said no inquiry report.
No, not only that, he will also kindly come to the no list of documents.
Did you file an appeal?
Yes.
You filed an appeal.
Yes, that
What
was
is the
appeal.
appellate authority?
Yes.
What orders were passed?
My lord, government, my lord, case 48. Passed by the government itself. my lord.
Page number?
38, my lord, by the government, passed the order.
No, no, appeal, appeal.
My lord,
Did you file an appeal? Did you file an appeal before the appellate authority?
37. Just a minute. Just 37. Yes, my lord. 34, my lord. Yes, sir.
34.
Yes.
34 is an appeal for against suspension.
Against suspension, yes. Against removal, no appeal is filed, my lord, because the authority passing the order itself was the government. Commission Secretary to the Panchayat Development. Once thereafter, my lord, while this was pending, he came to court. And your lordship directed them to complete the proceeding within 2 months. And this is the result.
Yes.
Lordship, can you fix the matter only, Lordship, Friday on?
You have to get the information.
Lordship, because Lordship, we have not traced out the file in our chamber also, Lordship. Sorry. We have not traced out the file, Lordship, in our chamber, Lordship.
They filed the affidavit, my lord, counter they filed.
Lordship, we have filed our, for respondent number 4, we have filed our affidavit.
If you have filed it, how have you filed it if your file is not traceable?
Lordship, but it was filed
You
on.
get instructions, we'll take it up at 2 p.m.
Lordship, kindly Friday,
2
Lordship,
p.m.,
if
2 p.m.
possible.
Find out from your office whether inquiry report was submitted or not.
Lordship, Thursday, Lordship, kindly, Lordship.
Why?
Because
Where is your office?
Lordship, Punjabari, but the official council was engaged in another matter, Lordship.
Is there
If
only one council for PNRD?
Lordship, there are two councils, Lordship. One was in court number 5, their matter is going on.
You
and
call
another
them
was
at 2
court
p.m.
number 5.
We'll hear them.
Lordship, if possible, Thursday, Lordship, kindly, Lordship. If possible, Lordship.
Thursday. All right, Thursday.
I'm obliged.
List on first. At the request made by the council for the PNRD. MS so and so. Mr. R.P. Sharma, assisted by Mr. Adhikari, appears for the petition. Thursday. No adjournment. 2013 matter.
Yes.
I'm obliged.
The Lordship has, my lord, raised the question whether Anganwadi labor worker, they are the government employee or in the service under government. And of course, my lord, I have examined this question. I didn't get any suitable answer. My lord, perhaps, my lord, they were appointed under certain scheme or certain policy. But fact remains that, my lord, they are getting their salary from public exchequer. And on this point, my lord, there are two decisions of our High Court, one by Honorable Justice Sanjay Medhi and Justice Bhujar. Relying on decision of Supreme Court, they are saying that once there is an allegation and on the basis of the allegation, some, my lord, punishment was imposed, he or she is entitled to get some prior opportunity, pre-decision opportunity of being heard. Because charge is there, my lord, there was some negligence in discharging duties. Then, my lord, And there is some incident took place on 1st of,
Who posed the question to you?
my lord has put the question. Whether they are in
On
government
which
service.
date?
If they are not in government employee, then my lord, disciplinary rule may not have any application. That is the pinpointed question raised by your lordship.
Whether the discipline and appeal rules are applicable.
Applicable or not. Lordship says, since they are not government employees, seems to be not government employee, therefore disciplinary appeal perhaps may not have any application.
Here, what happened here?
But in this case, may not, some penalty was imposed on the basis of certain allegation. And one FIR is also not pending. And under such circumstances, she was dismissed from discharge from service.
Where is that penalty imposed?
At page my lord, annexure I.
I.
At page my lord, 53. Yes. Therefore, it is a penalty on the basis of certain allegation. No DP was conducted, no opportunity was given. Then the petition was moved, court was pleased to grant stay. And there is a reference of, my lord, two judgment of our High Court. Court says once there is a disciplinary action and penalty was imposed in persons of disciplinary action, then Rule 9 will apply. And accordingly, what was status?
You had assaulted somebody.
My lord, that is the allegation. And she lost the affair, not against me. There is no any allegation against me, rather the entire allegation against the president of Center, Anganwadi Center. Rather, I lost an affair on the same very day. Even assuming that there is some allegation of assaulting my lord.
No affidavit.
No affidavit.
Yes.
Lordship. In the, it's a long pending matter, Lordship, and we have seen only one inquiry report pertaining to some complaint, Lordship. So this is there, and that apart, there is nothing. So if your Lordship may kindly allow me, because in that case, Lordship, I think no affidavit has been filed by the department because it was earlier dealt by the standing council, Lordship.
Which matter? This matter.
This matter, yes. Subsequently, Lordship, we are, and I think after a long time, Lordship, the matter has been listed. After 2017, Lordship, and in March 20.
No,
the
only
matter
question is whether any hearing was, opportunity of being heard was granted.
Yes, Lordship, that particular Lordship, I shall take instruction from the Director, Lordship, because the opportunity of hearing only by the Director, Lordship, in case of any complaint.
There is some inquiry report reflected.
Lordship.
They reflected on one inquiry report that by Deputy Commissioner. But no report was communicated to me, no opportunity was given to me, no notice was even served.
Inquiry pertains, Lordship, though it is forwarded by the Deputy Commissioner, but the inquiry conducted by the SP Nogam.
How can the SP conduct an inquiry?
Lordship, there is a police case, Lordship.
Maybe, but this is with
There's
regard
that
to disciplinary proceeding has to be different.
disciplinary procedure. Because they are the Anganwadi worker and helper, Lordship. I think the disciplinary appeal rules is not applicable to
May
them,
not be,
Lordship.
but at least some form of representation is conceived of.
Lordship.
my lord, with all due, my lord, respect, once matter was, my lord, dealt with by this court and arriving at a conclusion, it has got application, perhaps, my lord, the government advocate cannot raise this question or cannot make this submission because there was no appeal against that decision, true decision. Therefore, we must accept the proposition, it has got application.
Lordship, kindly allow us 2 weeks time, Lordship. We will be getting the instruction, Lordship. May finally dispose it.
2 weeks,
Lordship.
2014 matter.
Yes, Lordship. There is no other. Because now all the CDPOs and all are there in the engaged in the election duty, Lordship. So till 11th, all are occupied with this, Lordship.
We'll give you a week's time to find out.
Lordship.
It does not appear that any inquiry was done.
Lordship, I shall.
May I just,
Therefore, you have to now not only get your instructions, you have, with that effect, you have to get your instructions what happens.
Yes, Lordship.
Consequential orders.
Lordship.
may I, my lord, make a request, my lord? My lord, on 6/7, my lord, I'll go out of station, sir.
You give your date. 8,
My lord, I'm giving.
6th and 7th, you are out.
I'll go.
Then come back on 8th.
Lordship may fix the matter on 9th,
9th is a miscellaneous day.
on miscellaneous day,
Then on 13th.
on 13th.
Lordship.
My lord, it is a part-time matter, my lord.
At the request made by the learned counsel for the, sorry, by the government council, matter stands referred. Again, to be listed on 13th, enabling the government council to complete her instruction as to whether any opportunity of hearing was granted to the writ petitioner prior to her termination of service. Mr. Cody. Mr. Purkaster appears for the writ petition. 13th.
My lord, interim order may be able to continue.
What interim order?
Because she was, my lord, allowed to continue.
You are still continuing?
Yes, I'm continuing. Yes, stay order.
Interim order passed earlier will continue.
Obliged, Lord.
Bless you, Lord.
Yes, Mr. Nath.
My lord. This is a bank employee case, my lord. He was sent on compulsory retirement. Can I, before my argument, I can say, my lord, it's a hard case. And also there's judgment by your lordships against, not against me, but similar matter. When there's no loss, even then they can proceed. However, lordship judgment, it is also there. If there's a perversity, other things, my lord. Sir, confirm my argument on perversity, and in the criminal case, my lord, he was acquitted. He's the same person who was a witness in dependent proceeding. He was the witness there also, my lord.
No, maybe. Only question is whether the allegations are one and the same.
That's what, that's what. I'll place that for my lord.
Yeah.
Your lordship, in this case, only on 25th of March, we have filed our wakalatnama, and that the earlier set of counsel has been changed, your lordship. And right now we are having the writ petition in the affidavit in opposition, but not the entire brief of MEX in the other document. Only a short one.
Yeah.
I leave it, lordship.
The manner you opened, I thought you were beginning to argue, but perhaps you were.
No, no, what happened? I just please, instead of taking lordship to unnecessary documents, I just try to make a point that these are points I'll make my submissions on that.
All right.
That's the reason why I've said so.
How much time do you require?
1 week maybe, your lord. 1 week time.
All right. The joint request matters has papered for 1 week.
Thank you.
Yes.
My lord, this matter related to the age of the petitioner, my lord. The petitioner, he was in army personnel. In 1981, he joined in the army, and 2001, he retired after completion of 20 years of service, my lord. And 2007, he joined the AHTC as a driver on contractual basis. So as per the documents filed by him to the AHTC, his date of birth was 31/12/1962, my lord. And accordingly, he has to retire on 22 12 22.
3112.
31/12, my lord. He has to retire, my lord. But they have wrongly or not wrongly, intentionally they have given because the petitioner suffered an accident causing 80% disablement. And because of that, he wants to take retirement from the voluntary retirement matter. Voluntary retirement document application was written by them, where the date of birth of the petitioner was recorded at 1/1/1963, my lord. That is 1 year ago. And therefore he has filed a petition before the authority for correction of the same, but it was not done. So the petitioner filed, firstly they have, my lord, one interesting, they have filed an affidavit showing that the petitioner has submitted two PAN cards. One showing his date of birth as 31/1/1962 and one is 31/12/1962, my lord. You kind of see the affidavit filed by the respondent on 5/8/2023, my lord. Here the Annexure 1 is the copy of PAN card where the date of birth was shown as 31/1/1962. And another was shown as 31/12, but 31/12/2062 it is the correct because this one, the Annexure 1, says 35, it is apparently a forged document, my lord. It is apparently because of that Mr. Cowell, income tax advocate, he was appointed as amicus curiae to examine which is the correct. He has perhaps submitted report that the first one is forged, my lord. Annexure 1. Annexure 1 is forged. Annexure 2 is correct, my lord.
Forged means who will forge your document?
My lord?
Who will forge your document?
Yes. Their department, ASCC.
Department has forged document.
Because they have filed it. It has come from their possession. They have filed it.
No, it is available in your
They know
service.
who has, but we are submitting the correct documents. Our affidavit, my lord, 2017/1922, my lord. No, sorry. 31/3/2023. We are filing our document. Your lordship, kind of see. Copy of the PAN card, page 46, Annexure A. Is a copy of the PAN card which they have filed. And where the date of birth was 31/12/1962. And this is the Aadhaar card, my lord. Page 47, it is the Aadhaar card. Where the date of birth was recorded at 31/12/1962. So this is the correct date of birth, my lord. Apart from this, your
But
lordship,
there are judgments of the court.
my lord.
There are judgments of this court as well as the apex court that correction of date of birth is to be done 3 years prior to your retirement.
No, because the after retirement, at the time I was, they had forged the age. I have evidence, my lord. Your lordship kind of see the order dated 23/1/2023, my lord. 23/1/2023. As per this order, we are asked to, on the next day, Mr. Sharma.
23, which date?
23/1/2025.
Yes.
This order.
Yes.
As per this order, I have directed to submit the petitioner shall also place before the court the document issued to the petitioner on his retirement from the Indian Army, my lord. That is the actually, and I have brought it. Where the date of birth was, my lord, recorded at 31/12/2000, 1962, my lord. This is the original, my lord. This is copy. This is the copy of the document, my lord. This is the order.
No, you have to bring it on record by way of affidavit. We can't accept.
I am directed to place before a court, my
No,
lord.
no,
That is
no,
why I
not
am
like
saying
that.
it.
Not like that.
Earlier order. If that, then I will file by affidavit.
You have to file your affidavit and bring it on record.
Then that may be fixed. I will file by affidavit because earlier that I was asked to only place before a court, my lord. So I am following the order.
Counsel for the petitioner is permitted 2 weeks time to file additional affidavit to bring on record the documents issued by the petitioner on his retirement in army, wherein the date of birth of the petitioner has been recorded. Stop. Petitioner was earlier permitted by this court by order dated 23/1/2025 to place this document before the court. Placed after 2 weeks. Yes, our Dhaka is
For FTC alert.
for age.
Alert.
After 2 weeks.
Yes.
With your permission, Lordship, this is a matter with regards to the retirement that the
You wanted
petitioner is
adjournment.
seeking. Yes, Lordship. My senior is unable to
Alright.
attend, Lordship.
Matter stands deferred at the request of counsel for the petitioner. We
Lordship,
take
may
it
kindly
up to
fix
one.
another date.
The last date was fixed in your presence.
Yes, Lordship.
Then
Lordship, it was my senior's father's shot today.
that's right. So this was listed on 7/4,
Yes, Lordship.
not many months
Not
back.
anymore.
So we are not fixing another date. You mention it before the court when you want, right?
Lordship.
Yes.
May I please, Lordship?
You wanted upgradation.
Yes, Lordship.
Tell us.
Luckily, Lordship, before completion of first. Well, this is a case, Lordship, where the petitioner, Lordship, has been removed from service, Lordship, without initiating departmental proceeding. Your Lordship may kindly give the impugn order, Lordship, case 28.
28.
May I read that? Whereas complainant so-and-so, Bongaiga under Bongaiga district so-and-so, laws and FIR dated so-and-so, Bongaiga police station that found so-and-so, her 11 years old daughter was sexually assaulted by one Korun Gogoi, posted at so-and-so, he is the petitioner, okay? While victim was alone at her home. The said LNK, AB so-and-so Korun Gogoi, allegedly put the complainant's daughter on his lap and hugged her with ill intent. When another person arrived at the complainant house, the minor girl was able to free herself from his grip. In this regard, a GD entry was made by number so-and-so, dated so-and-so. A case has been registered by number so-and-so, under section so-and-so, with rate with section 10 of POCSO Act. Accordingly, I of the case so-and-so arrested Korun Gogoi is the petitioner and forwarded him to judicial custody. And so-and-so Korun Gogoi has been suspended from his duty as on so-and-so fight number 20. Whereas from inquiry, so conducted and after going through the inquiry report supported by the statement of the 15, recorded under section so-and-so, it appears that the allegation against so-and-so are serious in nature and substantiated and whereas this is important law.
Yes, continue.
From the whereas the Honorable Guwahati High Court in a case of Madhav Gogoi versus State of Assam in so has observed that both the provision of Article 311 2B and Rule 10 Roman 2 of the Assam Disciplinary Appeal Rules empowers the disciplinary authority to pass any such order as it deems fit, where the disciplinary authority is satisfied for reason to be recorded in writing that it is not reasonably practical to follow the procedure of holding the disciplinary inquiry, etc. A satisfaction has to be reached as to why it was not practicable to hold the inquiry, etc. Whereas Section 47(1) of Assam Police Act says the role and function of police is prescribed as to uphold and enforce the law impartially and to protect life, liberty, property, human rights, and dignity of the members of the public. And whereas act of so tantamount to gross misconduct, such kind of act of moral turpitude has brought embarrassment to the force and has affected the morale of the rank and file. His continuance in service even after such gross misconduct involving a minor girl is unacceptable and against the ethos of a disciplined uniform service. It would send a wrong signal to society and public if such an individual is allowed to remain in service. Other members of the public instead of feeling protected will feel vulnerable. Public interest does not justify his continuance in service. And whereas as per provision of Article 12 of the Constitution of India, Rule 10(2) of the Assam Disciplinary Service and Rule so dated so with due application of mind, I, the disciplinary authority, dismiss LNK number so from service with effect. My lord, he has terminated leadership without conducting any disciplinary proceeding and basically relying on judgment of this honorable court in respect of Madhav Gogoi. Lordship, I have annexed that judgment. In fact, this judgment will against the order, against the impugned order. That is, your lordship will find page 30. May I read, lordship? The petitioner DC so Madhav Gogoi is a constable in Assam Police has been dismissed from service by order so. The dismissal was on the basis of an inquiry of the Deputy Superintendent of Police headquarters that the petitioner behaved and response some allegations were there, lordship. And accordingly, lordship, in the same paragraph, the order of Superintendent of Police, lordship, just before 4-5 lines of the same paragraph. So provide that the dismissal was made without holding any disciplinary proceeding by invoking a power under same provision, lordship, he was dismissed. And this observation of this honorable court, lordship, paragraph 3, be that as it may, the order of dismissal was also issued under Rule 10 of Assam Disciplinary Service Rule 1960. Both the provision of Article 12 in respect of clause B and C to the proviso thereof, as well as Rule 10 of Assam Disciplinary Service 1963, empower the disciplinary authority to pass any such order as deemed fit, where the disciplinary authority is satisfied for reason to be recorded in writing, that is not reasonably practical to follow the procedure of holding the disciplinary inquiry, or in respect of Article so proviso thereof, the President or the Governor is satisfied that for the interest of security of the state, it is not expedient to hold such inquiry. The order dated so does not record any such satisfaction that neither it is practical to hold an inquiry, nor that it is not expedient to hold the inquiry in the interest of security of the state. In the context that condition preceding Article so proviso thereof to the Constitution, as well as that rule of Rules 1964, had not been followed to the extent that no satisfaction was arrived at in the writing as to why it is not practicable to hold the inquiry, or as to why it is not expedient to hold the inquiry in the interest of society of security of the state. We are of the view that order of dismissal from service against the petitioner by so would not be sustainable in law. Accordingly, the order dated so dismissed, set aside, and the matter is remanded back. My lord, relying these judgment order, lordship, he has passed the same order in respect of me also.
Do you have the copy of the order which was passed by the department in this matter, which was ultimately set aside?
No, that order is not.
But going by this order, reasons are there.
No.
Impugned order.
No, going by that is the order of this honorable court, your lordship will find that impugned order was passed in terms of the same provision that he has taken in my case. Article 311 2B, and
the only thing is that a satisfaction is to be arrived at in writing.
Yes, that is to be as per provision of the law itself, Lordship.
That's right.
Yes.
So there is a satisfaction here.
No, there is no satisfaction in this order, Lordship. If you Lordship kindly say under what?
Last paragraph
Which-
on page
It's a
number 28.
dismissal order, Lordship, last
Last
paragraph.
paragraph,
That's the satisfaction.
I am being, Lordship, there should be reason that why the.
See. Satisfaction and sufficiency of grounds for satisfaction, they are two different things.
My,
You are on the question of grounds for satisfaction.
my lord, my humble submission will be that.
The
There-
order which you are relying on
Yes,
only says the reasons must be there
yes,
in writing
yes,
as to why is it not practicable. to hold.
practicable.
That's right.
That is also, your Lordship will find in the provision itself.
Hmm.
If your Lordship kindly come to the provision of Rule 10.
Hmm.
Of the Assam Discipline and Service Rules, if your Lordship kindly come to the Rule 10, special procedure in certain cases, notwithstanding anything contained in Rule 9. Lordship, Roman 2 is important,
Yes.
relative. Where the disciplinary authority is satisfied for reason to be recorded in writing that it is not reasonably practicable to follow the procedure prescribed in the said. So under that circumstances, we can.
This is the reason.
No, there is no reason why the Department of Proceeding was not
This is the
practicable.
reason. Last paragraph on page 28. This is the reason.
I being the disciplinary.
Last paragraph of page 28,
Yeah.
Annexure 7 of your writ petition.
Yes. Whereas act as well, so tantamount to gross misconduct, such kind of. No, Lordship, regarding the Lordship reason of not initiating the Department of Proceeding, that is not
Is
there.
the reason. That is the reason.
Lordship, I am reading again, Lordship.
You can't say that it is devoid of any reason. You may argue that these reasons are not sufficient to override the provision. That is a different issue. But this is the reason why they did not proceed.
My lord, I am reading again, Lordship. Tantamount to gross misconduct, such kind of act of moral gravity has brought embarrassment to the force and has affected the morale of the rank and file. His continuance in service, even after such gross misconduct involving a minor, that is unacceptable against the ethics of discipline in uniform service. It would be sent a wrong signal to society and public if such individual is allowed to remain in service. Other member of the public institute of police will vulnerable. Public interest does not. No, these are the observation relating to allegation against me. But what
These
is
are
the
the reasons why your further continuance, because you see, if the proceeding is continued,
My lord.
you will be in, whether in suspension or otherwise, you are a member of the service,
No, I have already been suspended.
right? If you are suspended,
I am
but
not
you are-
in service.
What do you mean you are not in service? You are
At that time,
suspended.
Lordship, I was
Suspended.
suspended.
All right, but they have given a reason that your continuance in service would be affecting the morale and the confidence of the public in the public. That's the
My
reason.
lord, my submission is that what is the record of satisfaction that the in disciplinary proceeding initiation of
This is the reason.
disciplinary proceeding.
This is the reason. You tell us now, satisfy the court that these reasons are not sufficient to override the provisions of Rule 9.
These lordship, my humble submission will be
Mere
that.
humble submission will not do.
My lord,
You
these-
interpret from the rules, then support your arguments by authorities.
Madam, my submission will be that this reason cannot be a ground for
Your
not
submissions
initiating the
are
Department of
irrelevant,
Proceeding.
Mr. Counsel.
That he can.
There is a provision under the rules.
Yes.
You are not questioning that he did not have provision under the
No,
rules.
no.
He
I
has
am
given
relying on.
reasons. On what basis do we consider these reasons to be not worthy?
Where is the findings that because
Where
of
under
that
the rules, where
because
under
of
you point out under the rule that there is a requirement that there has to be a finding.
my
Show us from the rule.
no per lordship as per constitutional mandate under Article 311.
311 is even clear. For
My lord-
reasons in writing.
Yes, reason in writing,
Is
but
the
where
reason
is
in
the
writing?
it should be impractical for drawing Department of Proceeding. What was the reason for not doing Department of Proceeding? That
This
is
is
not
the
there.
reason. Why are you insisting that there are no reasons? This is the reason.
No, this may be the reason for dismissal from service. But this is not the
This is
reason,
also, this is exactly what has been stated here.
my lord, this may be reason for dismissal, but this cannot be a reason for not initiating the departmental proceeding.
You
There
can
should be
argue,
some,
we'll listen to you, we'll hear you.
if your lordship can be come
Any
to,
affidavit?
Lordship, this is our stand, Lordship, and if required, we'll file an affidavit also in the
We are
matter,
not asking
Lordship.
you to file. It is your decision whether an affidavit is required or not. If you want to file, you file. If you don't want to file, we close the hearing.
We will file an affidavit, Lordship.
Yes.
my lord, case lordship 32, this honorable court lordship, in the another judgment, where the disciplinary authority is satisfied for reason to be recorded in writing that is not reasonably practical to follow the procedure of holding the disciplinary inquiry. Or in respect of Article 12 so provided, the President or Governor is satisfied that for the interest of security of the state, it is not expedient.
Therefore, I asked you,
My lord.
do you have the copy of the order passed,
My lord.
which was available in the writ petition, which was ultimately set aside?
My lord, if your lordship permit me, lordship, sometime I'll place on record, lordship.
All right.
Or your lordship may take this writ petition with that writ petition, lordship. This either.
You get it. You are
Yes,
relying
lordship.
on this order.
Yes, lordship, I'll bring it on.
You get that order. Show us that the reasons were similar and the court had granted issued an
Lordship, I'll.
direction.
After a week, lordship, any date may begin.
Yes. How much time do you require to file your affidavit?
Lordship, 2 weeks.
Third, counsel for the parties, petitioner is permitted to place on record the order passed by the department which stood interfered with by order of this court dated 15/10/2020, passed in WPC 4212 of 2020, which the petitioner submits is an order which is similar in nature to the impugned order passed by the department. So, counsel for the respondent prays for further 2 weeks' time to complete her instructions and file necessary affidavit. List again. Prayers allowed. List again after 2 weeks.
Can it be on 20 of May, lordship?
2 weeks. All right, 20 May.
Obliged.